Hello everyone, welcome to Crystal Diaries. Now this is another video in the series of video relating to Indian Contract Act. And in this video, we are going to read about the rules regarding valid proposal and valid acceptance. I have also taught the important case laws in this videos. Please have a look through it. And for any prior information, you can look at the previous videos to understand this. So let's begin with that. But before we begin, please bring your BEAR Act, a notebook and a pen so that you can read the BEAR Act simultaneously and you can underline or highlight the important provisions and you can note down any important point in the notebook if you want. So let's begin. So section 2A of the Indian Contract Act says about proposal. What does it say? When one person signifies to another person his willingness to do or to abstain from doing anything with a view to obtaining assent of that other to such act or abstinence, he is said to make a proposal. Right? We have read this in our previous video. Now, what are the rules regarding valid proposal? So, here are the rules. So, let's begin. The first one is express or implied. So, the proposal should be either express or implied. Now, what is an express proposal? An express proposal is one in which the proposal is expressed either in words or in writing. That is either orally or in writing. Suppose if I write you a letter that I want you buy your car for rupees 2 lakhs. So, I am making a proposal, right? So, I am writing it. So, it is an express proposal. Now, what is an implied proposal? The best example is the auto or the bus stop. The bus that waits at the bus stop, it is actually in an implied way asking the customers or the passengers to get in. So it is making an implied offer. Now the second point regarding the validity of a proposal, that the proposal should create legal relationship. Okay, a legal relationship is different from social relationship. Now, what is social relationship? This we will understand from the case law of Balfour versus Balfour. So, what happened in this case? There was a husband and a wife. So, they lived in two different areas or two different places. The husband said to the wife that you stay here. I will be sending you money every month so that you can spend it for your monthly expenditure. So, he proposed this and the wife accepted it. So there was a promise between them, there was a contract between them. So after a few days, the husband started sending money to the wife for the monthly expenditure. But after some months, he stopped sending the money to the wife. So the wife moved the court and she said that we had a contract and he has breached the contract. So he has to pay compensation or he has to be sued for that. He has to be made liable. But do you think that the court held the husband liable? No, it did not hold the husband liable. But why? He had made an agreement, he had made a contract, he breached the rules or he breached his obligations. But no, the court said that when the husband said the wife about giving money for the monthly expenditure, that is a domestic agreement or that is a domestic talk that happens in every family. At that moment of time, their intention was not to get into a legal contract. So, since their intention lacked at that point of time, this cannot be said to be a valid proposal. Okay? It is sad, but it is true. So, the intention here should be to create legal relationships. Now, what is the third criteria? It is communication of offer. The communication of offer is very, very essential. What you are offering or what you want to convey, the second person or the person to whom you want to convey must have an idea regarding that. If that person is not having any idea regarding that, of course he or she cannot accept that offer and there will be no contract. So the main case law in this regard is Lalman Shukla versus Gauri Datta. So here what happened, Gauri Datta had his son missing. So Lalman Shukla was the servant. So she asked him, please go and find the son. So he went searching for him. So when he was out searching for the son, at that period of time, Gauri Datta made an announcement that whoever finds my son, I will get him money reward. And after some time or after a few days, Lalman Shukla brought her back the son. Okay, but after that, Lalman Shukla got to know that there was an advertisement or there was an announcement that whoever gets the son of Gauri Datta, she would give her the rewards, monetary rewards. So he went to Gauri Datta and he asked that, I found your son, now give me money. But Gauri Datta said, no, I have not made any contract with you. I have not communicated my offer to you. Then this is not a contract. So when it went to the court held that this is not the case of valid proposal. The servant had a duty towards his master that yes, that I will do whatever you ask me. Now if Gauri Datta had made a proposal to the servant and the servant fulfilled it, then only he could be given money. But in this case, Lalman Shukla did not have any knowledge regarding this offer. And when a person does not have any knowledge regarding this offer, how can there be acceptance? And when there is no offer and no acceptance, then how can there be an agreement or how can there be a contract? So the court held that communication offer is a very essential thing which lacked in the case, for which Lalman Shukla was not given any money. Now what is the fourth criteria? That the proposal should be certain and definite. It should not be vague or unclear. So let us take an example. Suppose there are two persons, A and B. A says that I will give you 5 liters of oil for 10,000 rupees to B. But is this offer clear or certain? No, it's not. Because we do not know what kind of oil is he talking about. Is he talking about mustard oil or is he talking about crude oil? We do not know. So the proposal should be very certain and definite. Now what is the fifth point? That conditional offer may be conditional, but if it is conditional, that should also be communicated along with the offer. You find that there are offers in the market where it says 50% off, but there is a star mark or hash mark at that point of time or at that particular label where it says terms and conditions apply. So here, if you are imposing any condition along with the offer, you must communicate the offer as well as the conditions to it. Okay, now moving the next part. The non-compliance of a term should not amount to acceptance. Like if I say you that, okay, I will give you rupees 500 and if you do not return me, then I will understand that you have actually sold me your horse. Now, is this a valid offer? No, it's not. Now, this can be understood from the case of Feldhaus versus Bidley. In this case, there was a person who said that I'm going to take your horse and I want to buy it. So, if you do not reply to my offer, if you do not reply to my letter, then I will understand that you are intending to sell that to me or you have accepted my offer. So the person who had the horse, he did not reply. So the person who had sent the letter, he assumed that yes, he has accepted my order or my offer. But the person to whom the horse belonged to, he sold that horse. Now the person who had sent the letter, he moved to the court and sued the other person. But do you know what the court held? The court held that non-compliance of a term should not amount to acceptance. So you cannot say that if you omit to do this thing or if you omit to do that thing, if you do not reply me, I will assume that my offer is accepted. So non-compliance of a term should not amount to acceptance and it is not a valid proposal. Now, what is the last essential of the validity of an offer? That offer and invitation of offer must be distinguished. And what is the relevant case law? Pharmaceutical Society of Britain versus Boots Chemist. I think I have taught about this particular case in the previous video. You can go and check that. So now, having known about the rules regarding valid offer, now let us know about the rules regarding valid acceptance. But before that, let us know what is acceptance. Now, if we read section 2b, it's written when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So when you are making an offer or a proposal to the other person and the other person agrees to it, so that is known as the acceptance of the proposal. And when a proposal is accepted, it becomes a promise. Now section 8 has also to be read along with section 2b, which says acceptance by performing conditions or receiving consideration. So performance of the conditions of a proposal or the acceptance of any consideration for a reciprocal promise which may be offered with a proposal is an acceptance of the proposal. So if you verbally accept whatever the person is saying, that amounts to acceptance. But along with that, if you are performing a certain condition that has been mentioned in proposal, that if you do that, then we will understand the offer is accepted, and if you do that, then also the offer is accepted. Also, if the person who is making the proposal, if he is giving you a consideration and if you accept that, that also amounts to proposal or the acceptance of the proposal. So let us take an example that if I write you a letter in which I write that okay, you please meet me near the railway station so that I can hand you the package. So you come to the railway station. So you are performing a condition. That means you have accepted my offer. Now receiving consideration. Now I send you rupees 5,000 in which I write that see I am sending you rupees 5,000. Please send me 5 books. Now if you accept that rupees 5,000 which is the consideration, that means you have accepted my offer. Now, so what are the rules regarding valid acceptance? So it must be express or implied. So the acceptance must be express or implied. When we can say that an acceptance is express? When you are saying it orally or you are actually writing and saying yes, I am accepting your offer. Now what is implied? We studied in section 8, if you're performing a condition or you're receiving the consideration, so that is implied acceptance. Now, we have to read an important case law, that is Carlyle versus Carbolic Smoke Bowl Company. I've already taught about this in the previous video. You can check that out. Now, the second condition is communication of acceptance by person to whom it is offered. Okay, this is also very important. As I told, in the case of Lalman Shukla versus Gauri Datta, like communication of offer is important, in the similar way communication of acceptance is also very much important. And who needs to communicate? The person to whom the offer is made, he has to communicate. Now what is the third thing? Silence does not amount to acceptance. See, we have read that if a person is performing certain condition, we can say that the offer is accepted. But if he is omitting to do something, if you say that if you don't do this, I will assume that the offer has been accepted, then this is wrong. Okay, we have read in the case of Feldhaus versus Bindley, in which the court held that silence does not amount to acceptance. Now what is the fourth one? That the acceptance should be absolute and unconditional. So it is given in section 7, if you read, in order to convert a proposal into a promise, the acceptance must be absolute and unqualified. Okay, so if the vegetable vendor is making you an offer that he will sell you potatoes for 20 rupees per kg, and you are accepting that without any condition, without any bargain, then that is acceptance. But if you say that no, I will purchase it for rupees 18, and he agrees to that, even though you buy the potatoes from him, you have not accepted the offer. Rather, this is a case of what? Counter offer. So the acceptance needs to be absolute and unconditional. Now it has to be expressed in some usual and reasonable manner. So if the proposal if that person mentions in the proposal that you have to say the assent, or you have to actually express your acceptance in a particular manner, you have to do it. But in case it is not mentioned, so you have to do it in a very reasonable manner. So the fifth one says about specific mode, that you have to say your acceptance, or you have to communicate your acceptance in a specific mode. Suppose if a person says that if you say me yes in telephone, I will understand that it is accepted. Now if you do not convey that in telephone, but you make a post to that person, then it is not accepted. But it is on the discretion of the person if he accepts or not. Now the sixth one is within reasonable time. So you have to accept the proposal in the fixed time or in the prescribed time, whatever is mentioned in the proposal. But in case no fixed time or any particular time is mentioned, you have to accept that within a reasonable time. Now what is a reasonable time? It differs from one matter to another. We have to see that on a case basis. Okay, so with this we complete the rules regarding offer and acceptance. I hope you like the videos, and please do check out the other videos relating to the contract in my playlist. Thank you and have a good day.